My name is Michelle Ferroni. I'm a criminal defense lawyer. We're here today to talk about DUIs, alcohol or drugs. You can be arrested for a DUI with drugs in your system as well, pursuant to 23152A of the Vehicle Code. Drugs being legal or illegal drugs, that being prescription marijuana if you're a medical marijuana patient, or illegal drugs. If you're ever stopped by an officer for suspicion of a DUI, whether it's drugs or alcohol, you do not have to talk to the officer. You don't have to take any of the tests the officer will request of you. That being the field sobriety test or any kind of physical agility test. You don't need to make any statements. The only test that is required of you is a chemical test, which is typically done either at the police station or at a hospital. If you're arrested on suspicion of a DUI with alcohol, you are required to take either a blood test or a breath test, and you do have that option. If you're arrested for a DUI with drugs, you are required to take a blood test. You're not necessarily advised of your Miranda rights when you're stopped for DUI, and I get that a lot. I think that people think that anytime you're stopped or detained for a crime that you need to be Mirandized or provided your Miranda rights. With a DUI, it's different. A DUI is considered an investigation, an ongoing investigation to the point of arrest. Therefore, statements can be made, field sobriety tests can be performed. The officer can, note objective signs of your behavior or your demeanor prior to arresting you. So all of that information or that evidence prior to an arrest does not have to be Mirandized. It's simply volunteered on the part of client. So I would advise somebody not to give any information when they're stopped. Simply ask the officer why they're being arrested, if they're being arrested, and if it's for a DUI, then take a chemical test. With DUIs and alcohol, it's a little bit easier with a chemical test to detect if somebody's under the influence of alcohol, because we have a level which measures your concentration, which is 0.8 or above. That's the law. That's not to say that you're going to be convicted because you're 0.8 or above. However, it is an indication that you are impaired at the time of driving. DUIs with drugs, specifically marijuana, is very difficult to detect the impairment. The reason being that marijuana or active THC, which is what is measured in your system, will stay in the system up to 30 days. And it's very difficult to state whether a person is impaired at the time of driving. There's no such threshold like 0.8 or above like there is with DUIs with alcohol. The other thing that's really important not to talk at the time of the arrest, if you're being arrested or suspected of DUI with drugs, specifically marijuana, one of the indicators that the courts will use later on to convict you or as evidence against you is if you admit to recent use of marijuana. It's really important not to make those statements, even if you have a medical marijuana card, because once again, it's very difficult to ascertain impairment at the time of driving, and to say that you just smoked or whatever way you consumed marijuana would be used as evidence against you.